ओके सो गुड मॉर्निंग टू ऑल ऑफ यू। आई होप ऑल ऑफ यू आर डूइंग ग्रेट। तो चलिए आज के डिस्कशन को हम लोग शुरू करते हैं। आज हम लोग डिस्कस करने वाले हैं एमपी सिविल जज 2019 फेज 1 शिफ्ट 1 के क्वेश्चन पेपर में जो लॉ का सेक्शन है उसमें पर्टिकुलरली इंडियन एविडेंस एक्ट, आईपीसी और सीआरपीसी के प्रोविजंस को। अगर आप लोग अभी पहली बार ये वीडियो देख रहे हैं तो देयर आर प्रीवियस वीडियोस अपलोडेड इन द सेम सीक्वेंस, जिसमें हमने जो सबसे लेटेस्ट एमपी सिविल जज का एग्जाम हुआ था उसके क्वेश्चन पेपर के रिगार्डिंग सारे अपडेट्स दिए थे। साथ ही साथ हमने उस पर्टिकुलर क्वेश्चन पेपर को इन डिटेल डिस्कस किया था, तो जाके वो पर्टिकुलर वीडियो आप लोग देख सकते हैं। एंड फॉर द अदर क्वेश्चंस रिलेटिंग टू एमपी सिविल जज 2019 फेज 1 शिफ्ट 1, उसके लिए भी एक कंप्लीट सीरीज ऑफ वीडियोस है विच इज अवेलेबल ऑन द चैनल। तो you can check out that particular videos as well. Link you will find definitely in the channel. एंड अगर अभी तक आपने रोस्ट्रम लीगल के चैनल को सब्सक्राइब नहीं किया है तो प्लीज जाके हमारे चैनल को सब्सक्राइब कीजिए एंड डोंट फॉरगेट टू प्रेस द बेल आइकन so that whenever me or any of the faculty like we are coming live, so you will get an update regarding the same. Usually 9 a.m. to 10 a.m. in the morning, usually we meet up with the discussions of various things like till now we have discussed various static GK thing. Then we have also discussed about MP previous year question papers. So you can find all those videos in the channel. And अगर अभी तक आपने एमपी सिविल जज प्रीलिम्स के क्रैश कोर्स को ज्वाइन नहीं किया है तो डू चेक इट आउट, लिंक इज इन द डिस्क्रिप्शन बॉक्स. There you can find 10 plus mocks, one-on-one mentoring and doubt clearing sessions, recorded video lectures for all the subjects. So don't forget to check that out. Now let's start with today's discussion. Today we are going to take up from question number 71 of 2019 phase 1 shift 1 question paper. So here the first question is, this question is relating to Indian Evidence Act. The question is, under which of the following sections of Indian Evidence Act a witness under examination gets the right to refresh his memory? I'm repeating the question again. Under which of the following sections of Indian Evidence Act a witness under examination gets the right to refresh his memory? Your options are section 158, section 159, section 160 and 162. Here you have to understand Indian Evidence Act से you will find ample number of questions जो कि directly आपके section number based होते हैं. So this particular question, question number 71, is directly based on section number. So its correct answer should be B for Bangalore. That is section 159. Section 159 of Indian Evidence Act talks about refreshing of memory of a witness. Next question, question number 72. That is, the principle of res judicata is provided in which of the following section of Indian Evidence Act? I'm repeating the question again. The principle of res judicata is provided in which of the following section of Indian Evidence Act? Your options are section 140, option B section 40, option C section 164, and option D section 160. So what should be the correct answer? Yes. For this particular question, the correct answer will be again B for Bangalore, that is section 40. Section 40 simply states that the cases which have been decided previously, they will be considered as a conclusive proof for any other new case. So that is the principle of res judicata inculcated under section 40 of Indian Evidence Act. Next question is question number 73, again dealing with the Indian Evidence Act, that is stating A prosecutes B for stealing cows from him. B is convicted. A afterwards sues C for the cows which B sold to him before conviction. Full stop. What will be the importance of judgment of B's conviction between A and C's suit? So here the problem is quite simple. They are simply asking that A prosecutes B to stealing cow from him. Then later on B has been convicted. Now before conviction B sold that particular cow to C. And now A wants to recover the possession of that cow from C back. So what will be the relevancy of B's conviction between the suit between A and in this suit of A and C? Option A relevant, option B irrelevant, option C conclusive proof, and option D none of these. Now, if you have followed up Indian Evidence Act direct closely along with the illustrations, if you will follow up section 43 illustration C, right? There you will find the same problem. So it is a illustration based problem, and its correct answer is again B for Bangalore, that is irrelevant. So the conviction of B will not be a relevant thing between a suit between A and in this suit of A and C. Now next question, question number 74. Statement of relevant fact by a person who is dead or cannot be found is relevant. Statement of a relevant fact by a person who is dead or cannot be found is relevant. Option A, under civil proceedings only. Option B, criminal proceeding only. Option C, neither in civil nor in criminal proceedings. D, both civil as well as criminal proceeding. So what should be the correct answer for question number 74? Yes, its correct answer will be D for Delhi. That is both civil as well as criminal proceeding. So a statement of a relevant fact by a person who is dead or cannot be found is relevant in both civil and criminal cases. Now, next question is question number 75. Which of the following could be proved as dying declaration after the death of the person? So this question is related with section 32 clause 1, that which of the following things can be considered as dying declaration? Option A, FIR lodged by person deceased. Deceased means the person is dead. Second option, statement of the person deceased or dead recorded under section 161 of CRPC. C, statement of the person deceased, that is dead, recorded by the executive magistrate. And D, all of these, yeah, all of the above. So I'm repeating the question again. Which of the following could be proved as dying declaration after the death of the person? A, FIR lodged by the person deceased. B, statement of the person deceased recorded under section 161 of CRPC. C, statement of the person deceased recorded by the executive magistrate. And D, all of these, yeah, all of the above. So question number 75, its correct answer is going to be D, yeah, all of the above. In all of these cases, like the statement given by a deceased either in form of FIR or in form of a statement under section 161 or a statement recorded by executive magistrate, all of these can be proved as a dying declaration. Next question, question number 76. A kills C thinking C as B. A kills C thinking C as B. Now this particular question is related with your IPC. This is the first question of IPC. So A kills C thinking C as B. A is guilty of offense punishable under option A, section 301 of IPC. Option B, section 304 part 1 of IPC. Option C, section 302 of IPC. And option D, section 304 part 2 of IPC. Now section 301 of IPC is talking about doctrine of transferred malice. What is the meaning of this statement? Like if one person decided to kill someone and on the place of killing that person, he kills someone else. 304 part 1 of IPC is talking about punishment for culpable homicide. 304 part 2 of IPC is again talking about punishment for culpable homicide only in the cases of knowledge. See section 302, all of us are aware, it is talking about the punishment for murder. So here the students may get confused. They may mark option A, that is section 301, considering that this particular principle, like this problem, is related with doctrine to transfer of malice. But actually section 301 doesn't provide any punishment. The punishment for 301 is also provided under 302. So its correct answer will be C, Calcutta. That is option number section 302 of IPC, right? Now, let's move towards next question. Question number 77. A police officer detains a person in lockup despite production of bail order from the court. Here you have to understand what they are trying to convey, that a police officer detains a person in the lockup despite production of bail order from the court. The police officer is guilty of A, abduction, B, wrongful confinement, C, wrongful restrain, and D, kidnapping. Question number 77. I hope I am audible and visible to all of you. If that is the case, please let me know in the chat section that yes, sir, you are audible and visible. So, A police officer detains a person in the lockup despite production of bail order from the court. The police officer is guilty of A, abduction, B, wrongful confinement, C, wrongful restraint, and D, kidnapping. Question number 77. What should be the correct answer? Jaldi se bataiye. What is the possible correct answer? Yes, its correct answer will be, yes, its correct answer is B for Bangalore. That is wrongful confinement. So if a person detains, a police officer detains a person after getting the bail order, it is considered as the offense of wrongful confinement. Question number 78. That is, question number 78 is based on general exception. Now, the question is based on an illustration. It is stating Z is carried off by a tiger. He fires at the tiger, knowing it to be likely that the shot may kill Z, but not intending to kill Z, and in good faith intending Z's benefit. His bullet gives Z a mortal wound. Option A has committed the offense of murder as malice transfers with the bullet. Option B, A has attempted to murder Z and wildlife animal tiger. C, A has committed no offense, and D, none of these. Now, if you remember, in the previous classes, those who have attended previous classes, I have clearly stated this thing. Whenever you are getting a word that is good faith, there always you have to remember what you have to remember, that the person cannot be held liable. Here option A, B and D are not talking about this. So naturally its answer will be C, that A has committed no offense because he was acting in good faith with due care and caution for the benefit of Z, right? Next question. Under which section of Indian Penal Code fabricating false evidence has been defined? Options are quite close, and again it's a section number based question. Option A, section 191, option B, section 192, option C, section 193, option D, section 197. Yes, so under Indian Penal Code, fabricating false evidence has been defined in A, section 191, B, section 192, C, section 193, and D, section 197. Now, if you people have read IPC, you will be having idea. Section 191 is talking about giving false evidence, not fabricating false evidence. Option B is talking about fabricating false evidence, while section 193, that is option C, is stating about punishment for giving or fabricating false evidence that can be up to 7 years and fine. So its correct answer will be option B for Bangalore, that is section 192, right? Now, because they haven't asked for the punishment, they have asked like which section defines fabricating false evidence. So its answer should be B for Bangalore. Next question. Which of the following is not an offense? Question number 80. Question number 80. Which of the following is not an offense? Your options are A, suicide, B, murder, C, preparation to dacoity, and D, attempt to murder. Which of the following is not an offense? A, suicide, B, murder, C, preparation to dacoity, and D, attempt to murder. Please let me know I am audible and visible to all of you, so that I can move further in a much smoother way, right? So which of the following is not an offense? Question number 80. What should be the correct answer? Jaldi se bataiye. Suicide, murder, preparation to dacoity, or attempt to murder. What should be the correct answer? So its correct answer will be option A, that is Ahmedabad. This is suicide. Now remember, attempt to commit and suicide is an offense. Attempt to commit suicide is an offense, but once you have completed the suicide, it cannot be considered as an offense because dead body cannot be penalized. Only the living person can be penalized. So its answer will be A, right? Next, question number 81. A instigate B to burn Z's house. B sets fire of the home and at the same time commits theft of the property there. Full stop. A is guilty of option A, abetting burning of Z's house only, B, abetting burning of Z's house and theft, C, theft only, and D, none of these or none of the above. So A instigated B to burn house of Z, but rather than burning the house, along with burning the house, what B has done, he has also committed theft. So A will be guilty of abetting of burning of Z's house only, abetting of burning of house and theft, C, theft only, and D, none of these. So its correct answer will be A, Ahmedabad, that is abetting burning of Z's house only. Here you have to understand this thing much clear way, that if A was having a good knowledge at the time of instigation that particular crime can be committed in that series of accomplishment of the crime which has been instigated, then A could have been liable for multiple number of offenses committed by such person who has been abated. But here it is clear that burning house and theft are two different type of offense which has no reasonable rational nexus or no relation. So its correct answer will be A, Ahmedabad. Now, next question, which offense does not require number of 5%? Question number 82. Which offense does not require minimum number of 5 persons? A, Rioting, B, Affray, C, dacoity, D, none of these. Which offense does not require minimum number of 5 persons? A, Rioting, B, Affray, C, dacoity, and D, none of these. So what should be the correct answer for question number 82? Yes, I'm waiting for your answer. Please let me know in the chat section. I'm waiting for the answer, then only I'll move further. Just let me know what is the correct answer for question number 82. That will give me a confirmation that I am audible and visible to all of you. Please let me know if I am audible and visible. Because as of now, I haven't received any response. So ideally, I don't know I am audible and visible or not. Please let me know question number 82 ka answer, or like I am audible or visible, something like that, so that I can get a confirmation. Yes, I'm waiting for that, please. Kamleshwar Dondrialji, yes, you are answering for question number 82. Like Kamleshwarji, try to write down the question number as well along with the answer. Yes, for this particular question, which of the following offense does not require minimum 5%? So its correct answer is B for Bangalore, that is affray. Affray is fighting at a public place. So fighting at a public place can be done between 2 or more people. But for rioting, for dacoity, we will be requiring 5 or more person. Yes, Kamleshwarji, its answer will be B, affray. Remember, for dacoity and for rioting, we will be requiring 5 or more person. Like if you will read section 392, 393, 391, you will be getting clear idea that for dacoity, like robbery turns into dacoity when 5 or more person adjoins together, right? And rioting is like use of excessive violent things by the unlawful assembly. To constitute unlawful assembly, again we require 5 or more person. So its correct answer will be affray, which is defined under section 159, right? Next question. Which of these is not a mode of abatement under Indian Penal Code? Which of these is not a mode of abatement under Indian Penal Code? Your options are A, attempt, B, aiding, C, instigation, and D, conspiracy, right? Question number 83. What should be the correct answer? Which of the following is not a mode of abatement? Like if you have read section 107 of Indian Penal Code, you will be having idea it is talking about abatement under Indian Penal Code. So which of the following is not a mode of abatement under Indian Penal Code? A, attempt, B, aiding, C, instigation, and D, conspiracy. Yes, what should be the correct answer for question number 83? Let me know quickly. What should be the correct answer for question number 83? Which of the following is not a mode of abatement under Indian Penal Code? Yes, its correct answer will be A, that is attempt. Remember, if we will read section 107, it is simply stating that abatement can be done by aid, instigation, or by criminal conspiracy. So its correct answer will be A, that is Ahmedabad, that is attempt. Question number 84, voyeurism. Voyeurism is punishable under section of dash Indian Penal Code. So which of the following section we can say defines the punishment of voyeurism? Your options are section 354A, section 354B, section 3. Kamlesh ji bol rahe hain. Yes, sorry, I am unable to pronunciate your name. Khangembam. Okay. Can I call you KN? Is it okay? Yes, KNG. A ka like 83 ka correct answer will be A. Voyeurism is a punishable under which section? 354A, 354B, 354C, 376A. So voyeurism, like if you have read section 354, you will be having clear idea that section 354C is talking about voyeurism. while section 354D is talking about stalking. So 84 का correct answer will be C, Calcutta. That is section 354C, right? It is defining the offense of voyeurism, right? Next. Yes, 84 का C is the correct answer, KNG. 85, question number 85. A sends a mobile phone to his friend through his servant B. The servant took the phone at his house and used it over a period of time. B is guilty of the offense of. A sends a mobile phone to his friend B and through his servant B. The servant took the phone at his house and used it over a period of time. B is guilty of the offense of. Option A, theft. Option B, criminal misappropriation of the property. Option C, criminal breach of trust. And option D, cheating. Yes. What should be the correct answer for question number 85? Like a person sends a phone to his friend through his servant. The servant took the phone and used it over a period of time. So the servant will be held liable for which offense? Theft, criminal misappropriation of the property, criminal breach of trust, and cheating. Question number 85. Its correct answer will be C, Calcutta. That is criminal breach of trust. Here you have to understand, you might get confused. Tapas Karji, bilkul C is the correct answer for question number 85. Now, that is criminal breach of trust. Here you have to understand the difference between criminal misappropriation of the property and criminal breach of trust. Criminal breach of trust can be committed only if a person has been entrusted over that property. तो यहां पे आपको ये देखना है, A has voluntarily given his phone to B, who was his servant, to transfer it to C. So A has entrusted B over that phone. So that's why its correct answer will be C, not B. That is criminal misappropriation of property. Now, next question. Z, the doorkeeper of Y, is standing Y's doorway. A commits house trespass by entering in the house, having deterred Z from opposed him by threatening to beat him. A has committed. Now, A has committed which of the following offense? Option A, house trespass. Option B, criminal trespass. Option C, lurking house trespass. And option D is house breaking. House trespass, criminal house trespass, lurking house trespass, and house breaking. Which of the following offense has been committed by that particular person? A. Right. What should be the correct answer for 86? Its correct answer will be D for Delhi. That is house breaking. Here you have to understand, house trespass is simply entering into the house. Criminal trespass is when you enter into the house of someone with a criminal intent, with a mind to commit an offense. That is criminal trespass. Lurking house trespass is you have made the house trespass and then you have hidden yourself at some place. That will be lurking house trespass. And house breaking is entering into the house by not following up the constraint which has been there. Okay, so here Tapas Karji, for which question you are answering B? If it is for 86, its correct answer will be D, that is house breaking. Why? The reason behind it is the simple question from the illustration of section 445, that is talking about house breaking, right? Next question, question number 87. Which section will be attracted if a public servant commits rape on a woman in his custody? Which section will be attracted if a public servant commits rape on a woman in his custody? Question number 87. So which section will be attracted? Your options are section 376, subclause 2A, section 376, subclause 2D, section 376, subclause 2G, section 376, subclause 2B. What should be the correct answer for question number 87? Question number 87, yes, its correct answer will be section 376, subclause 2B, B for Bangalore. That means its correct answer will be D. D option, Delhi, is stating section 376, subclause 2B, which is stating about commission of offense of rape by a public officer on a woman who was in his custody. So its correct answer will be D for Delhi. Next, question number 88. That is, can a person commit a criminal breach of trust for his own property? The question is a C for question number 87. No, KNG, its correct answer will be D. That is section 376 2B, right? Question number 88. Can a person commit a criminal breach of trust for his own property? Option A, yes. Option B, no. Option C, it will depend upon facts of the case. And option D, it will depend upon discretion of the court. The question I'm repeating again. Can a person commit a criminal breach of trust for his own property? Option A, yes. Option B, no. Option C, it will depend upon the facts of the case. And option D, it will depend upon the discretion of the court. So question number 88, its correct answer will be A, that is yes. Yes, a person can commit criminal breach of trust on his own property. How? Let me tell you. Like suppose I have insured my house. Suppose I have taken insurance of my house. Then to recover the amount of insurance, I have intentionally burned my house. So here I have committed criminal breach of trust for my own property. So question number 88, its correct answer will be A, that is yes. Next question, question number 89. In which case Honorable Supreme Court has directed to pay the minimum compensation of rupees 3 lakh per acid victim? In which of the following case, question number 89 is stating, in which of the following case Honorable Supreme Court held or directed to pay the minimum compensation of rupees 3 lakh per acid victim? Option A, Lakshmi versus Union of India. B, Sujoy Mitra versus Union of India. C, Vanagat Anuradha Samir versus Vanagat Mohandas Samir. D, Indra Vijay Alok versus State of Madhya Pradesh. So its correct answer will be yes. Question number 89. What will be the correct answer for this question? Honorable Supreme Court has directed to pay a minimum compensation of rupees 3 lakh per acid victim. In the case of, its correct answer is A, Lakshmi versus Union of India. I'm sure all of you would have heard the name of this case. If you haven't heard the name of this case, then you would have heard the name of a movie called Chhapak, in which Deepika Padukone was the actress. In that particular movie was based on this case only, Lakshmi versus Union of India. In this case, Supreme Court of India held that per acid victim should be paid at least 3 lakh rupees compensation, right? Question number 90, that is stating the offense of section 361 is basically against. Now here, when you are attempting question number 361, you should have an idea that what section 361 is talking about. So section 361 is basically talking about your kidnapping and abduction wali situation. So section 361 is basically an offense against A, family, B, society, C, any living person, D, lawful guardianship. Question number 90, what should be the correct answer? A, family, B, society, C, any living person, and D, lawful guardianship. Yes, so this particular question's correct answer will be D, that is lawful guardianship. So the offense of 361 is again basically against lawful guardianship. That was the last question of IPC. Now let's move towards CR.P.C. Question number 91. It is based on CR.P.C., that is Criminal Procedure Code. The question is, the court after the commencement of prosecution evidence allow the assistant public prosecutor to withdraw the prosecution. The accused shall be A, released, B, discharged, C, acquitted, D, none of the above. For which question, Prasida ji, you are answering for which question? Just let me know, Prasida ji, for which question you have marked D. Try to write the question number as well. Question number 91. The court, after the commencement of prosecution evidence, allow the assistant public prosecutor to withdraw the prosecution. The accused shall be A, released, B, discharged, C, acquitted, and D, none of these. So its correct answer will be option C, that is acquitted. Now, do not get confused, because if you will read section 321, that is also stating about like withdrawal of the case, but that is the withdrawal of the case by the complainant. Yes, KNG, C is the right answer for question number 91, right? So do not get confused, its correct answer will be acquitted, right? Question number 92. There shall be no appeal by convicted in following. In which of the following case the there can be no appeal by the convicted person. A, where a magistrate of first class passes a sentence only of fine not exceeding ₹100. Option B, where a court of session passes only a sentence of imprisonment not exceeding 3 months. Option C, where a high court passes only a sentence of imprisonment for a term not exceeding 6 months. And D, all of these. Question number 92. Please read question number 92 very much carefully and you will get the answer. Where a magistrate of first class passes a sentence only of fine not exceeding ₹100. Option B, where a court of session passes only a sentence of imprisonment not exceeding 3 months. Option C, where a high court passes only a sentence of imprisonment for a term not exceeding 6 months. And D, all of these. So its correct answer will be question number 92. Correct answer will be D, all of these. Now लेट मी टेल यू, यहां पे आप एक और इंफॉर्मेशन छोटी सी ऐड कर सकते हैं क्वेश्चन नंबर 92 के साथ. Where a court of session passes only a sentence of imprisonment not exceeding 3 months or fine of ₹200 or both. In that case, no appeal can be done by the convicted person. Where the High Court passes a sentence of 6 months or fine of ₹1,000. In those cases also, there can be no appeal by the convicted person under CRPC. So its correct answer will be D, all of the above. Now, next question, question number 93. If a person who is competent to compound an offense is dead, the compounding is, now A, cannot be done, B, can be done by the legal representative of the deceased without the permission of the court. Option C, can be done by the legal representative of the deceased only with the permission of the court. Option D, none of these. If the person who is competent to compound an offense is dead, the compounding A, cannot be done, B, can be done by the legal representative of the deceased without the permission of the court. Option C, can be done by the legal representative of the deceased only with the permission of the court. Option D, none of these. So its correct answer will be yes. Question number 93. Its correct answer will be C. It can be done by the legal representative of the deceased only with the permission of court. ये चीज हमें कहां मिलती है? This particular provision you can find under section 320 of CRPC. KNG, for which question you have marked A? Just let me know. Try to write the question number as well. Now, next question. Question number 94. If after the evidence in the opinion of the magistrate accused is guilty, in which he does not have the right to punish the accused with the maximum punishment prescribed for the offense, then under what section with the written opinion he can submit his proceeding and forward the accused to the chief judicial magistrate? Question number 94. Option A, section 321. Option B, section 322. Option C, section 323. And option D, that is section 325. What should be the correct answer for question number 94? Right. देखिए एक बार question number 94 and you will get the answer. Its correct answer will be section 325. Because section 325 of CRPC is stating when the magistrate is not empowered to inflict sufficient severe punishment which is required for the offense, he can transfer the case or he can submit the case to the chief judicial magistrate. So its correct answer will be D. Question number 95. Under Criminal Procedure Code, in which section provision of security for good behavior from habitual housebreaker offender is made? Now, they are simply asking that security for good behavior from habitual offender, any of the habitual offender including housebreaker, can be taken under which section? Option A, section 106, option B, section 107, option C, section 109, and option D, section 110. What should be the correct answer for question number 95? Yes, question number 95 ka correct answer will be A, that is section 106. Now, option D, that is section 1010. So it is simply stated under section 1010 that a person, like if you want to take security for good behavior from a habitual offender, that can be taken under section 110, right? Next question, question number 96. What it is stating that the statement recorded during investigation under section 161 of CRPC by the police, A, cannot be used for any purpose during the trial, B, can be used only for corroborating a witness. C, can be used only for contradicting a witness. D, none of these. Question number 96. This is the same question recently appeared in Haryana Civil Judge Prelims exam as well, right? So what should be the correct answer for this particular question? Question number 96. Statement recorded during investigation under section 161 of Cr.P.C by the police cannot be used for any purpose during trial, can be used only for corroboration, can be used only for contradicting a witness, and D, none of these or none of the above. So its correct answer, question number 96, correct answer will be C. That is, can be used only for contradicting a witness, not for corroborating a witness, right? So its correct answer is C, Calcutta. Question number 97. Pardon may be tendered to an accomplice under section 306 of CRPC when A, he is not in a position to stand trial due to infirm health. B, he is declared insane. C, he undertakes to make full and true disclosure of the facts relating to the offense, and option D, all of these. Question number 96. Yes, C is the correct answer. KNG. C is the correct answer. Question number 97. Pardon may be tendered to an accomplice under section 306 of CRPC when he is not in a position to stand trial due to infirm health. B, he is declared insane. C, he undertakes to make full and true disclosure of the facts relating to offense, and D, all of these or all of the above. So question number 97, its correct answer will be C. That means if he undertakes to make full and true disclosure of the facts relating to the offense, then the particular offender may be tendered pardon, right? Now, next question, question number 98. And which of the section of CRPC 1973 provides that the person accused of an offense shall be a competent defense witness? Which provision of CRPC states? Yes, KN C is the correct answer. Question number 98. Which section of CRPC provides that the person accused of an offense shall be a competent defense witness? Your options are A, section 312, option B, section 313, option C, section 314, and option D, section 315. Question number 98. What should be the correct answer? For question number 98, the correct answer will be D, that is section 315. Here I'll suggest you section 311, section 311A, 313, 313 and 315. These are very much important provisions. So try to follow all these provisions closely. Here, if we will talk about 315, that is the correct answer for 98. It is simply stating that the accused person can be a competent witness of defense, right? Question number 99. That is, if the succeeding judicial magistrate is of the opinion that further examination of any witness whose evidence has already been recorded is necessary in the interest of justice, he may resummon any such witness, and after such further examination, cross-examination and re-examination, if any, as he may permit, the witness shall be discharged. This provision is mentioned under dash of CRPC. Your options are option A, section 326, option B, section 325, option C, section 311, and option D, section 319. So what should be the correct answer for question number 99? Now, let me tell you, question number 99 is talking about succeeding magistrates. Like when a case, a trial has been partly decided by one magistrate and partly by another succeeding magistrate. So this particular provision you can find under section 326. So its correct answer will be A, that is section 326 of CRPC is stating about the same. Now, moving towards next question and the last question for the day. What is the maximum period of imprisonment for releasing on bail under section 436A of Criminal Procedure Code? What is the minimum period of imprisonment for releasing on bail under section 436A of CRPC is provided? Option A, 1/4 of the maximum imprisonment of the offense. 1/4, option B, half of maximum period of imprisonment. Option C, 1/3 of maximum period of imprisonment, and option D, no period is prescribed. Question number 100. 1/4 of maximum period of imprisonment. Option B, half of maximum period of imprisonment. Option C, 1/3 of maximum period of imprisonment. And option D, no period is prescribed. Yes. So question 100, what should be the correct answer? Let me know quickly what should be the correct answer for question number 100. Yes, its correct answer will be half of the maximum period of imprisonment. So its correct answer will be B for Bangalore. Now, I hope whatever we were planning to discuss today, like you have attended the session, so you would have learned something new. Those who have attended the session from the middle, they can watch this video again, and if they are having any confusion, they can drop a doubt in the comment section. Don't forget to like the video and to subscribe the channel. Like if you found it informative, like we put a lot of effort to make those videos, to discuss those question papers with you. If you find it relevant for you, don't forget to like the video and subscribe to our channel. Question number 100, correct answer KNG, it will be B, that is half of maximum period of imprisonment, right? And if you haven't till now followed up Judiciary MP Civil Judge Prelims crash course, link is in the description box. Do check it out. There you can find the recorded video lectures for all the subjects, 10 plus mocks, one-on-one mentoring and doubt clearing session. Last time we have made 22 plus selections in the exam of MP Civil Judge last year in prelims. Even some of our MP Civil Judge prelims last year's crash course student also qualified for mains. So that will be very much important to make your preparation smooth. Do check out, the link is in the description box. And thumbs up to all of you. See you people all in the next video with some more discussion. See you all tomorrow at 9 tomorrow.